Sorry, that's the first time we're doing the hybrid event. We're still working out when to start. I don't want to do it twice. I'm very calm. Are we online? Yes. We're online. Good night. Okay, so now we just come up. I'm sorry, you have to bear with us today. It's the first time we're doing it. I think this will be will become the new normal. Good morning to everybody. If it wouldn't be for the online part of things, I think we would be still outside and having coffee. I haven't seen so many of you in such a long time, and I enjoy it so much. So I would rather stay outside and continue chatting with you. But we need to get on with that because there's people at the desk. For all of you, and it still feels good after using Teams calls to look in the screen and not really see who's responding. So all of you at home, at your desk, or at your house, at your home office, very welcome. I'm very sorry that you missed the reception. The breakfast was really good. It was lovely seeing everybody. Yesterday, our marketing manager, Chiara, she said, "Oh, I hope everybody who signed up in person is coming," because we had to say no to a lot of people because we were full on the number. And I said to Chiara, I'm sure everybody is coming because we are all missing the actual events and actually seeing each other. So listen to that. I was giving a very short time. Why we want to do this event? Because our clients have asked us. You have asked us. I have asked our department, because I have the same questions you are all having. We had a very serious overhaul on laws. Nothing new. That's happening very frequently in the UAE. The UAE is coming very fast with fixes to any kind of gaps we are having. But this time, what affects you, whether you run a company or you are living here, working here, is the new employment law. Because there's a lot of changes and there's a lot of questions coming up for all of us. So we were saying, on the other laws, we have a short presentation, and I really promise to keep it as short as possible. On the employment law, we will have a small panel here. I'm very happy that our good friend Hussain Hadi from Nexis, he agreed to moderate because we have such a massive amount of questions that came already in beforehand. And to you, audience, you can see on the screen, you can see that you can ask questions. Type a question. You cannot see my colleague and I were sitting on the side. We're looking at the questions and we're passing it on to the speaker. So your questions will be answered as well. If there will be too many questions and for some reason we cannot deal with all of them, we will keep them and answer them later. Either make a link or go back to you directly. So as you see, Dr. Laura, my very best colleague, an amazing corporate lawyer, she gives you a presentation, a short overview on all the major laws. There are more laws that change, but it's just too much. So we try to focus on the most important changes. My colleague Shehab, esteemed colleague Shehab, he would speak on something very important. All of you who know me personally, for years I've told you to secure your contract, to secure your position. The easiest one is get a security check. Get check. If there is anything, bounce check. There's a lot of pressure on it, easier than having any enforcement later. There's a decriminalization. I have a lot of questions here with all the people who are in prison right now because of bounce checks. I will be on asking later questions, I guess. So that is very important, even more for you. If that is your system to secure your contracts with checks, and you have a huge amount of checks somewhere in your back office, you need to review. You need to review what you're doing about this now. So that will be quite important. Then there's the changes in the commercial company law. I looked at the slides, so I hope you're not totally confusing us. But again, Laura is running it, and Laura is extremely good, and we'll put it in small portions so we can all follow up. And I'm not sure if we have time, we will have a very short coffee break. At least for you at home, you can quickly grab a new coffee. Otherwise, here in between, if you want a coffee, maybe you quickly go out, because we have to play by here how the timing is. I know everybody needs to go back to the desk. And then, as I said, the interactive panel on the new employment law. Any questions you have at each topic, ask the question at the end of each presentation before we jump to the next. The laws, the biggest problem for everybody who's running an office here. Where do I get hold of the law? I'm reading the news in Gulf News, and Gulf News makes sense a link. On the employment law, I'm clicking on the website of the Ministry of Labour. I find the link, but the link is in Arabic. Now I Google around a bit, law firms, floating translations. If you're a law firm or you have a subscription with Nexis has the translations amazingly fast, Hussain, I have to say, amazingly fast. We got the execution law, the labor law, we got it was published on Saturday. I think Saturday evening, Nexis had the English translation. I don't know how you did that. That was very impressive. But again, you need to get hold of the law. You need to understand it. We are a bit worried in our office because quite often there's a discrepancy between the English version and the Arabic version. That's a bit tricky if you haven't got Arabic stuff in your office to actually get it checked. So we're getting into more details on that today, on the different laws. I think with this, I can already pass on to Laura, I guess. You had your coffee, Laura. Thank you so much.
Thank you, Jasmin. Good morning, everybody. It's our pleasure to host this event. I sincerely hope that you are going to find it useful, informative, and we are here always to respond to your questions. For the ones who do not know me, my name is Laura. I am a counsel in Fichte Co. I work in the corporate commercial department, and I'm a lawyer. A lot of lawyers today here. Indeed, we are passing historical moments. As in any society, there are paradigms that shift. There are changes that are being triggered in the legislation in line with the societal evolution. So we are passing one of these moments in UAE, provided that at the end of last year and the beginning of this year, 2022, we have not more than 4 major laws coming into effect. Some of them came into effect since 2nd of January, some of them came into effect a couple of days back from 2nd of February. So for now, our main topics of discussions are, number 1, the changes in the commercial companies law, they are major. Number 2, the problem or the amendment overhaul over the execution of checks. They are not executory. Number 3, an unprecedented development in the federal system, which is the data regulation. And number 4, and probably the most important of all, is the new employment law, which aims to restructure with the generational impact the employment market in the onshore UAE. For the clarification of the scope, these federal laws apply in the federal system, means outside the financial zones, which is GIFC and ADGM, as everybody knows. But with regards to the other free zones, call it DMCC, Dubai Internet City, Fujairah, other Emirates, obviously we are going to face the full applicability of this law there too. Our discussion is going to be structured in a couple of panels. The first one would look into the changes in the execution of bounce checks, what kind of liabilities these attract, what kind of enforcement procedures do we have at hand, followed by an overview of the commercial companies law, which again has brought some unprecedented changes. We have new SPVs regulated that would allow IPO securities and bonds for a higher, let's say, profitability of the market. For the joint stock companies, they are highly regulated by SCA, Securities and Commodities Authority. And in furtherance, we will refer to data. How does this apply to the new legislative realm, and followed by, as a joint discussion on employment, where I am sure that everybody has a lot of questions. Moving forward, I would like to give the floor to my colleague, Mr. Shehab Mamdouh, who is a senior litigator, a well-experienced lawyer, and he's going to dismantle for us the myth of the new legislation on balance sheets. Shehab, you are invited. Thank you very much.
Good morning, everyone, and thank you, Laura. We gathered today to talk about, as Laura said, the new amendments which have been recently happening in the UAE. One of these things which I will tackle today, which is talking about the balance check. I don't know whether it's good news or bad news. However, everyone should check now and not being scared about the sequences. But this is not correct. Why? Because the whole news in the UAE is talking about it's not going to be a criminal offense anymore if the check is out, which is not correct. Only one part of that has been decriminalized, which is when the check is returned for insufficient funds. We will discuss that in details a bit later. So initially, the balance checks was here one of the main security instruments for all the commercial entities where you can secure your money for a simple reason. Because if the check bounced, it's immediately can be submitted to the police and it will be a criminal offense, which is pushing the issue of the check to settle that at a point, being prosecuted or went to jail or being travel banned. All these kind of things. But the numbers of people in jail before that was a lot, especially for small amounts of check, for rent cases, for car loans, for a lot of things. They could go to jail for a check like less than 100,000. So there's a new amendment happened to that which stopped this. Any balance check below 200,000 is only a fine. Above that, imprisonment and fine will be applied. However, the new amendment has cancelled that law, which basically cancelled 3 articles of the penal code, which is starting from 401 until 403, which basically we're talking about the imprisonment for any balance check. New law that came out has decriminalized only the balance check for insufficient funds. What does that mean? It means that I issue a check to a second party. This check, when it's coming to be cashed, the bank will respond to there's no sufficient funds. In this situation, I will not be able to. This situation, the holder of the check can go after me in is a civil or commercial claim, but to be jailed or prosecuted will not be applicable here. And when I'm talking about this part, we will have to tackle which parts of that will be criminalized. If I issue a check to someone and then before the due date, I just go to my bank account and completely empty or give an instruction to the bank to not to release the check or how we call it, fake my signature. This part still falls under the criminal law. However, it's not in the penal code; it's in the commercial code, in the commercial law, which is applying. Right. Who's slide? Yeah. Okay. So the new commercial law basically is starting from Article 401 to Article 643. Basically, describes and identifies what are the criminal factors for any balance check, which is I just briefed you about it. There are more a lot points to be discussed, but these are the most important Now we will talk about the procedures to recover the lost check. Here? Okay. Now, if I have a bounce check, I cannot go to the police to file a police complaint anymore. What I have to do now? Now I have to go to the court. How I will do that? How this will be efficient to me? How fast it will be? When can I get my money? What actions I can take against the issue? All these questions come up. We all know here that enforcement procedures before the court might take a lot of time, which can be up to 2, 3, 4 years just to enforce or to execute the judgment, which is somehow it's not a strong security to guarantee the payment of any due money or any due amounts to be paid. However, the new law came up with the granted the pulse check, the power of an enforceable document which I can immediately file an execution. I can go to the court, register my execution, start the procedure. Previously, it wasn't like that. Previously, I had to go to the police, file a complaint. When the police start to investigate, then get the information from the bank. Why the check is bounced? Then after that, I can file my civil commercial claim, which will be a normal claim, starting like it can be like up to 3 instance court to do that, which might take a year or a year and a half until I reach a final verdict, a judgment for an enforceable judgment. The new law granted the check the power to be enforced immediately. So I just go to the court, say, I have this bounce check, I have the bank application that we bounced, I want to register my execution. And then after registering the execution, what would be required for me to do in terms of documentation, information, and how it will be done? As I said, once the check is bounced, the bank is obliged to provide me with a statement and the document showing the name of the issuer, the details of his contact details, and the details of his bank accounts, what he has with the bank. If not, they can still, with other banks, they still can contact the central bank, provide any other bank accounts that he has, and as well as his passport, his Emirates ID, and the visa. And if he's an employee, the name of his employer, and what is the reason for this check being bounced. And this is very important, because if the reason of the check bounced just for insufficient funds, then the court, the execution judge, will proceed with the application enforcement. If not, then it has to be transferred to the concerned judge to talk about or to discuss whether it's a criminal act or not, according to Articles 641 to 643. And then once I do that, I have to register my enforcement as a normal procedures, which is in any circumstances done in any litigation, which is I have to fill an execution form with my details as a claimant, which contains my Emirates ID or passport or visa, and then my contact details, and then my bank account in case for any recovery of the money. So the recovered money can be transferred directly to my account. How long this process will take and how much it will cost. Previously, to file a claim regarding the bounce check, the court fees is basically around 6% of the claim amount. And depending which court, it can be up to 40,000 EAD. Now, it will only cost me around 5,600 dirhams. Despite the amount of the check, it's 2,000 dirham or 2 million dirhams. So the court fees now is reduced, which is basically will be the execution court fee, which is capped by 5,600, 5,700. Once this is done, the court will start to notify. This is my main issue with that. Notification of the other party takes time. Depending whether the address which the bank will provide is still valid or not. People here change address maybe every year, or twice a year, or leave the country. So this will be a big problem to reach the issuer of the check to notify him for me to start the enforcement process. And it will cause a delay. However, the new law to avoid this part allowed me as a claimant to request the judge to put a travel ban, as well as investigate about the opponent's assets, bank accounts during the period of the notification, which was not applicable before. Now it is applicable. So in case he tried to escape the country or fly away or hide his assets, the court now knows that no, he has his assets in such a bank, he has a car, he has a property, he has this. It will not be seized, it will not be frozen, it will not be attached unless the notification is done. But even though if he will act or do something during this period, we still can nullify it to protect the claim. Whether it will be enough to protect the recovery and secure, put much security in the trade market and in the commercial society here or not, I don't know. How it will be fast and efficient, I don't know. Previously, it might take a lot of time. We have some executions filed since 2018, 2016, 2015, and still we did not manage to recover anything. And the opponent is still here, still working, still having income, still having bank account. But it's a separate entity, separate under different umbrellas, so they know how to treat the law. So the new law, in my opinion, has taken this strong security which was provided any trader, which is the fear of imprisonment, away. Is this going to affect the markets? We will see. Is this going to make more problems? We will see. But so far, I'm not very impressed about it, even though a lot of people might be against what I'm talking about, but this is the nature of it. What would be the time frame? Time frame, as I said, it can vary between, like, once I file the execution, I have 15 days to notify the opponent. The opponent has 15 days, which will be freely acting and doing transactions. And if he's willingly paying the claimed amount, then my case is closed within this 15 days. If not, then I can proceed with my enforcement procedure, which is, as I said, travel ban him, request the court to imprison him if he didn't pay, attach his assets, attach his bank accounts, and any belongings of movables or immovables I can freeze, and then this will be sold in public auctions for me to recover. How long this might take, as I said, can take between a month, which is the minimum in my opinion, and up to 2, 3, 4 years, depending on how wealthy or how financially stable is the opponent. What is the other thing might protect me as a check holder on that if any check issue will fall under this category where they have us checks for more than one time, then the court might request the bank to withdraw their checkbooks. They will not be allowed to have checkbooks by an order will be given by the central bank. This might affect his trade, this might affect his work. However, how this will be applicable and how it will be implemented, it's not done yet, but we hope it will be done efficiently, this is how it works in other jurisdictions, which is if I have any default when it comes to money, I will not be allowed to have some financial transactions, bank support in terms of loans or anything. So because my credit report will show that I am not strong enough, so I will not be allowed to have facilities for this should be applied as well in the UAE, because this is, I guess, how to protect the trade. Is it more efficient to recover than UAE? Is it more security? Is it more secure to recover? I don't think so, because as I said, imprisonment was a big deal. Threatening someone going to jail for default of payment is a big deal. So it gives more security for people to recover their money. Just the police, when they call someone, you have a bounce check, please come here. They will immediately take out all lawyers, go do whatever they can do before reaching to the police and meeting with them, try to sort it out. So reach a settlement, pay part of it, do something. So this part has been taken off, and the substitute of it, which is for recovery, it might be lengthy. It's not scary anymore for people. Like who has done that a lot, they know how to trick it, they know how to avoid it, they know how to escape from it. So this is that's why I was a bit against it in this form. Any questions?
Thank you, Shehab. I have a question because I think I do not agree with you. I see that the criminal effect of bouncing a check is still there, only when you are in good faith and your account is empty when the check is collected. But if you write a check and there is no money in it, or you take the money away earlier, it's still criminal, or not?
It is, as I said. So the criminal part still exists in when it's intentionally done to be in a bad faith, not to allow the holder of the check to encash the money, to recover the money.
But it starts at the beginning. So if you sign knowing that you cannot pay, it's already criminal.
This will be under the under the discretion of the court to prove the bad faith.
Cannot hear anybody if you are speaking.
Sorry, because this is a practical issue, right? As a claimant, then the onus of proof lies on the claimant to prove that there was an intent, criminal intent. You know, in the sense that they forged a signature, it could be under one of those categories that we discussed. The challenge will be the onus of proof, number one. So still, it's sort of blocked, you know.
That's my point. Is okay if someone issued a check and they know that they don't have the date of issuance of the check is I don't have enough money, but I know when the due date comes, I have the money in my account. But something wrong happens, the money is not there. Then here is the good faith. I was not planning not to pay. I'm planning to pay. That's why I issued the check. If to prove otherwise, so the claimant has to prove to the court or to the judge that this person has intentionally done that not to pay. That's why if I change my signature in the check, I give you a check, instead of signing Shehab, I put any other name, or I sign a different signature. Then when the bank responds and see two different signatures, then it will be a criminal offense.
So you just can take the signature mismatch notes
Exactly.
from the bank.
Exactly.
And you think that itself will qualify to be a criminal?
This,
aspect?
yes, as per the law, this would be a criminal act.
From again a practical perspective for a claimant, if it's a criminal nature that is attached to a circumstance like that, then there will be a penalty as per the new law. There
Penalty
is no
and imprisonment.
Yes.
As per the new law, there is penalty and imprisonment, which falls under separate categories. There are even some penalties and imprisonment up to 25 years and up to $500,000 dirhams. When it comes, if the money of the check or the issuer of the check or any transaction has been related to this check involved somehow in any terrorist or any act. However, if it's a fake signature or I false my signature, then it's 50,000 dirhams plus up to 6 months imprisonment. So it does exist if I am an issuer of a check, somehow provided it or issued it in a way not to allow the check holder to encash it. But if everything falls as per the requirement of the to issue a check correctly and as per the requirements of the central bank, but only the reason of the check bounce is insufficient funds, here the bank, if there is any money, if I issue a check with 100,000 in my account is only 50,000, so the bank can still encash you this 50,000, and you can still go after me, civil or commercial, for the balance amount. So here there is no criminal act anymore. Only insufficient funds, no criminal act. But any other thing for bouncing the check will fall under the criminal act.
Okay. And can you also
To prove, and just to be back to Jared's question, to prove whether it's a criminal act or not, I intentionally made sure the bank has no money on the date of issuing the check. It will be the burden of the claimant to prove it to the court. And then, even if you prove it, the judge will have the discretion to decide whether this is a criminal act or just an insufficient fund based on the normal circumstances. And then the application of enforcement will either move on or stop and be transferred to the prosecutor.
Thank you. Also, I'd like to know under what circumstances, under the execution proceedings, can one seek a travel ban? Because you said,
as I said, once you apply for the enforce the check, upon submitting your request before the execution court, you can request immediately the court to travel ban the person, as well as to investigate about the person's assets. But no action will be taken until the notification is done. So we will come back to the same issue, which is the notification process. Notification process can take up to 2 months, 3 months, because you're still gonna investigate, you're still gonna check where is he. You go to if it's a company, you need to check from the authorities, where are the current addresses? You go to the addresses, the company is closed, everyone works from home, then you have to re-notify them again. And then, so it's a very long process and request to submit to the court. Each request, you submit a request to the court to respond to you. It can take up to 5 days for you to enforce or the request that you have asked for. So it is a lengthy process.
Hi, I'm from Marasli. My name is Vasu. Now let's take a scenario. A person is working here. He can't pay. He loses his job. He goes back to the country, and he's in the country, and still he is not capable of paying. So what is the procedure? I mean, once he gets a job, can he pay back from his country, or how it works out?
Well, if he's outside the UAE, this is different, because as long as the criminal part is not involved anymore, you cannot go after the person through international, like Interpol. The alternative thing that you can do, if there is a treaty between both countries, UAE and the country of origin of the other person, to enforce civil or commercial claims, then you can go after him by starting and initiating a new proceedings to enforce it at his country of origin. Otherwise, if he willingly decide to pay, then a settlement will be in place, and then the court you may seek the court approval for settlement, where the court will schedule the payment monthly or quarterly or yearly, depending on the amount and the agreement between the parties. But this is the normal procedures in any enforcement. So this will apply anyway by default to this court.
Hi, good morning, Shehab, and thank you for the insight. It's been very informative. I have a question. During your narrative, you made mention that there are cases wherein the person who was issued a check which is bounced is kind of operating under a different name and has assets and stuff under another name. So how would that get viewed from a court's perspective when the judgment has to be executed, when the execution has to be done? Will the connectivity be created, and would that be taken into cognizance to get a favorable judgment in case if let's say a person has defaulted and not decided not to pay?
Okay, here we will talk about one thing. The identity of the check is very personal. It's either under a person name or under a company name with the power of a signatory person to sign on behalf of the company. So once it's under a person name, the only thing that you can do is to go after me in person. What I own in person, what is under my name. But you can, if I am a partner in a company, or I have shares, or I am a manager of a company, just a manager, you cannot go after that. You would in general, however, you still can go after my shares. But in practice, it is very difficult because the court here, the companies has a liability, has an identity. So it's like the court will sometimes, well, okay, we block the shares. Then where is the money? There's no money coming. If the company has a different account than the account registered or somehow managed to do it through other ways, there's no money coming to this bank account to identify my shares. Even if my shares come in, is it just a profit which I should get or not? Or just these shares will be, or the money coming in will be used for the day-to-day function and expenses of a company and profits happen. So it's very difficult to apply that. And when it comes to a company, then the company is liable. However, the check issuer, as a manager, he is liable on behalf of the company under the statute of a manager, not in person. So you cannot go after him in person. That is why it is a bit difficult.
So basically what you're suggesting is that if there indeed is connectivity with the second company and they have assets and capital available under the second name, it will be very difficult to connect and extract money out of it. If it comes to that.
Exactly. If both companies are LLC, limited liability, at the end of the day, if it's one company versus other company, the court will always say this is different. This has a limited liability, so their liability will be limited according to their assets, to their bank accounts, to their belongings.
Good morning.
Good morning.
How are you?
I am very well. How are you? Good to see you.
The general message going out from the UAE government on this matter, is there a message to the general business community for them to come to this country and open their establishments here? Are they sending message that we are relaxing the rules of check bounce being not subject to police case, or is this a mandate to reduce the workload on the police? What is the general message that is going out to the international business community for them to do business in this country? It can be, I mean, we understood all the legal procedures involved in going to the courtroom and everything, but I would like to hear from you, what is the general government's mandate in incorporating these or relaxing these rules about check bounce?
Thank you, Mr. Ayer. Did you ask that question? Sorry, I just asked if I can. Seem I have an echo here. I just asked if I can cut in because I have exactly the same point like you. I'm sorry, I disagree with you on the point if the new law is good, because since I came here, I was lobbying for decriminalizing checks. I cannot recall ever in Europe to have issued a check. I'm old, but not that old. Here, all of a sudden, I had to give security checks. You buy a car with a car loan, of course, you give security checks. rent security checks, office space security checks, insurance security checks, and it's really hard to keep track. And there's a constant Damocles sword on top of me with all the security checks. I am an investor, I'm self-employed, I don't know what's happening in 5 years. Today is okay, tomorrow is not. I definitely haven't got a bad intention. But the problem of the security checks for our clients are traders. They give security checks for the amount of 500, 600 million dirham. And there's again, we had issues in our office with our clients. A deal was done. The client is maybe an Indian company, not based here, not aware about the check law, not asking the security check back. So now again, the next deal, they got blackmailed. Agree to our terms, or we bounce the check and you go to prison for the next 10 years, considering the amount. So there was a whole mafia around the security check. So for me, this message to finally decriminalize, to finally stand up against the lobby of banks and insurance companies and car houses who use the security checks to put pressure on everybody. I think bottom line, it's a very good message to the industry to get more on international terms, how we deal. That's my opinion.
I agree with you at certain points, as well as just I'll start with the questions from Mr. Nair. Yes, a lot of publicity previously was against the UAE, or not only the UAE, the Middle East, for criminalizing the bounce check, because I guess we are the only part of the world that this criminal act exists. However, I would understand it in a different countries where people are stable, where people are there for 20, 50, 6 years, or even live there all their lives. Here, the turnover is a lot. The turnover of companies is a lot. How easy you can change from one company to another. In 1 day you can, in 2 days you can, in 3, so to avoid liability, the laws and the regulations applicable here allow people to use that to somehow not to pay. So, in my opinion, I am against it to be a criminal act. However, for the sake of security, to keep things running, it is, I would say, it's still important. Why? If I know that I am going to default, then I will think twice before issuing the check. I know if I'm driving and I break a red light, I know I'm getting fined. So it's the same thing. We are not like the law here when it's putting it as a criminal act. It's not lying. We're not saying no, issue a check. Don't worry, you will be fine. No, the check bounce, you go to jail. So you make sure to fulfill your obligations. However, if there is opposite security can be provided for people, because as I said, in Europe, I will not be able to have any facility. I will not be able to have bank loans. I will not be able to have support from a third party or financial institution. If my credit report is down, here I still can open a company. I still can have another trade. I still can have a different bank account. I still can have my wife's or my brother or my sister under their name and still work. So using the law in a way to protect yourself is making other people right might disappear. We think, if I think on behalf of the check issuer, yes, I want it to be like, it's not criminal act, I want it to be a civil act, I want it to be a commercial act. But if I think on behalf of the check holder, if he cannot recover, no, I want it to be a criminal act because I want my money. What is the main thing? What is the main thing of being lawyers and being litigators? It's not winning the case, it's recovering the money. So they putting it as a criminal act was somehow providing sort of security in here. This is my point of view, Jasmin. I agree with you for human rights, for everything, shouldn't be a criminal, but the atmosphere in the UAE and the attitude, the trade attitude, and the commercial attitude push us somehow to accept it. As I said, one day I took a car loan, and when the crisis happened, how many cars were being with the keys in the airport? How many? People just fled the country. Bye bye. Where the bank's money? To sell the car after 2 years after finding it, how much the car will worth? If a car worth like 200,000 after 3 years being parked, it will be lucky if you get 20,000 for it. Where is the money? The bank money. Where is the landlord money? So in my opinion, it should be somehow different security measures or a faster track for enforcement, not to put it under the same procedure of enforcement, just to secure people's right. Like if the law comes out and tell me you have a bounce check, I immediately travel ban him without just notification. Okay, that's acceptable. So I'm sure he's not going to leave the country. I'm sure about that. I am sure that you immediately freeze his assets. Okay, if he has objection or he has paid part of the money, then he can propose that to the court within 15 days. So no big harm will happen. This is my opinion. I might be wrong, but this is how I see it.
But what I see here is, this is going to reduce the workload of the police station for arresting somebody on false checks. And it's good luck for lawyers to have more cases of defense.
I was going actually to talk about that, but I'm sorry, I walked in. You want to ask something?
Chris has to be the last question.
Okay.
Well, it's not really a question, it's a point. First of all, I agree with Jasmin that the decriminalisation makes sense. But when you talk about your point of view is purely from somebody who's clearly worked in enforcing against people who are deliberately committing crimes. Whereas if you want the business community to open up here and you want people to come over here, then taking away this actually makes sense for the law-abiding citizen who just happens to fall on bad luck or does something accidentally. When I sign company checks all the time, if I've got 10 checks in front of me, I guarantee you that there are 10 different signatures. And every once in a blue moon, the bank will return one with a signature not matching. We just reissue it and send it out. That shouldn't be a criminal offence.
No, it's here.
But your point is all from people deliberately being criminals. In the maritime business, we have one company per ship, and then we consolidate them into holding companies up to the top company. So to me, the company's law is a bit incorrect there. Because if somebody opens up as a director of a different company here, then you should be able to go after that company. If I do something wrong with one of my ships, somebody can go and arrest one of the sister ships. So if you apply that to companies' laws here, if someone is deliberately defrauding under one company name, but it's the same person, just because it's a different LLC, then the company law should allow the common directorship to transfer over and prosecute the second company.
I fully agree on that. I think as well, I think Shehab, what you said, one system goes down, another system has to come up. Better credit rating. There's, again, it hurts me when I see that we could not invest. You have a client, they haven't been paid, they go to a judgment, they pay an endless amount of money on legal fees, court fees. Finally, we have the judgment. Our opponent is closing the company, is opening another one. We can do nothing. His house is on his wife's name, car is on the son's name. We can do nothing, and it really hurts. But you can see how emotional this topic is. Because again, there's the people who are just, it's not our fault, not our intention. And other people who are just misusing the absence. I think we need to stop this. It is a very emotional discussion. I give you.
It is, but as I said, for honest people, they will make sure that they should pay. It will not go there because once the check bounces, you get a call from your bank or you get a call from the opponent for the holder of the check. Check is bounced. You said you changed it immediately and provided. Some people doesn't do that because they know if now, and they will not do it because they know it will take a long time. Why would I pay now? If he filed an execution, I can pay in 2 years.
Thanks so much, Shehab. Thank you. We will not spend time, and I hope our online, so for all further speakers, keep the microphone really close because we have complaints that it's problematic to hear from outside. From a very emotional topic to a very commercial topic, right? There is a whole update on the commercial companies law and the data law. As Laura was already saying, data law so far hasn't really been present in the country, and now finally it hits us. I hope it means we stop receiving the unsolicited calls from everybody who gets our numbers from the department. That will help a lot. So I hand it over to Laura. Thanks.
Thank you, Jasmin. Thank you, Shehab. I have to agree, we had a very emotional discussion. Let me please give you the perspective of a corporate and business lawyer on checks. The idea behind criminalizing the check is the bad intent. The intent to defraud. So that is not new. This is a legal principle that exists in any regulation around the world. Any democratic, civilized, emerging economy punishes the intent to defraud by using a payment instrument. The problem in UAE was that prior to these amendments, the idea of bad faith in issuing a check was literally not being applied in practice, although regulated. The change came in order to alleviate the risks and incentivize the market, incentivize the community abroad. Dubai, UAE is willing to be an investment hub. In order to attract investments from abroad, you need to incentivize the market. But the idea is that this change in the legislation is not fundamental and the principle is still there. Let all of us be reminded that the UAE, aside of the IFC or ADGM, has a civil law legal system and the power of a judge to evaluate the intent, in a commercial business dealing is almost discretionary. So from a business point of view, yes, I see it as an incentive. However, from a practical perspective, it is a matter of structuring. A good business lawyer would advise the clients to invest in pre-litigation, not in pre-litigation. Litigation is an overhead. It takes time, as my colleague Shehab explained. It is a painful process for a business. Therefore, the purpose of a good business lawyer is to allow their client to mitigate at a minimum possible the legal risk. Finally, it is a point that we need to consider on the financial discipline and the financial regulation overall. Let's be reminded that until very recently, the UAE did not have much international pressure from international intergovernmental organizations. This pressure came to the picture now. You don't have only the problem with checks, you have problems with the economic substance regulations, you have UBOs, you have cooperation mechanisms in between the Ministry of Finance taxes from here and in other parts of the world. You have a specific mechanism that is being put in place for double taxation treaties. So basically the discussion is much wider. Yeah. The idea behind, however, making these laws is to indeed incentivize the market and to make, let's say, at least at the principal level, the jurisdiction more attractive, more predictable, more open for foreign investors. That's the idea behind it. All in all, we advise contingency and careful dealings on a case-by-case basis. In practice, the situations are very different. So one may not leave from the assumption that, I have a bounce check, I'll not go to jail. That's wrong, right? Okay. Now, moving forward to the second law that we have under discussion for today, and actually the third one, we discuss about commercial companies law and data regulation in UAE. The commercial companies law is not new. Most of the companies in the market are LLCs. I believe that anyone who is involved in business has knowledge on how the LLCs work. Another sector of the market, which is particularly regarded by this new law, looks into public joint stock. We are moving into very new market trends, NFTs, tokenization, IPOs, listing companies, making them more powerful. And for this reason, probably the most significant change that was introduced by Law 32, Federal Law number 32, that came into effect in January, was the creation of two new, very unprecedented new forms of SPVs, a special acquisition vehicle and SPV used for structurings, IPOs, mergers, acquisitions. These elements are brand new. They have never existed in the legislation here. Public joint stock companies now can be divided both vertically and horizontally, and these concepts actually come from where the financial and capital markets have been invented, which is the US and the Western jurisdictions overall. So this idea for creating two new types of joint stock entities that will respond these mergers and acquisitions and structuring, corporate structuring needs are made in order to respond to the same principle, which is incentivizing the market and attracting more prolific, sound investments from abroad. Now moving to what has changed in the law, what do we need to do in the business community? I would say that the most significant changes that appear are for limited liability companies and joint stock. Partnerships still existed in the old law, are being kept in the new law. Now, any owner of a company here and any foreign investor would happen to ask, what is happening with the 100% foreign ownership? This has been a discussion for years. It is now coming to a solution. The new commercial companies law still allows 100% foreign ownership. The famous Article 10 from Law 2 of 2015, the previous law, is still repealed. The framework that has been created by the Foreign Direct Investments Law, repealed as well, is being maintained. Therefore, the business community should rest assured that the list of activities that has been approved by the corporate regulators in the country as open for 100% foreign ownership is being maintained. Now, I believe that these are good news. We have done in our turn a series of corporate restructuring for our clients successfully. Therefore, it is happening and it is there on the condition that the licensed activities are in the approved lists. Now, for limited liability companies, obviously, most of the business setups in the market fall into this bracket, limited liability company. Now, the pierre angulaire of this LLC, as per the new law, is flexibility. What has changed? I would say that the investments of the shareholders are more structured and permit this flexibility which was needed. It is much easier now to convoke a General Assembly meeting. It is much easier now to lawfully adopt resolutions at a General Assembly meeting without reaching an unwanted situation of a shareholders dispute. It happened many times in the past. Very important, it is mandatory as per the new law to include a dispute resolution mechanism in the memorandum and articles of association. Why is that? A very simple thing, because nowadays we know that same as the public order matters, any dispute can be arbitrated. Why not the shareholders disputes? Why not investment disputes? Why not, let's say, adding more flexibility to the shareholders in, let's say, running an LLC? Secondly, what is very new for LLCs, the shareholders willing to save a company from distress can actually apply to the court in order to oblige the other shareholders to make capital contributions in order not to render their specific company as insolvent, or incapable of paying debt. Overall, when it comes to LLCs, it is a matter of structure. Obviously, what is recommended for the business community is to amend the Articles and Memorandum of Association in order to respond to the new law. The buffer period is of 1 year, and I am sure that the corporate regulators, these three zones authorities, are going to apply fines in the alternative. But overall, as a corporate lawyer, we deem these changes as optimal. They're in the parameters of other regulated jurisdictions. And overall, they do add a little bit more flexibility for the limited liability companies we own. Now, if we move a little bit forward and discuss about joint stock companies, for the joint stock companies, things are even more diverse. We've discussed in the beginning about these new types of SPVs. Now, these SPVs are regulated in the realm over all of the joint stock entities that need to ensure a certain flexibility, but at the same time, a certain surety, security over the financial dealings. Now, very good news is that the Founders Committee, for a joint stock company, are allowed to bring in contributions in kind. The prospectus for issuing an IPO or for, let's say, regulating a joint stock entity bring a specific liability to the issuers. So basically, in counterparty with this flexibility that has been added, right, there's a new compliance overhead which lies on the IPOs. Moreover, the nationality of the board of directors, of members, is no longer open for only UAE nationals. The law has changed in the sense that even, let's say, foreign entities, foreign individuals are allowed to occupy such a position. Finally, it is very important that the directors and the shareholders in joint stock companies have now the right to directly open suits, claims for damages against, let's say, alleged debtors or alleged defaulters under the IPO, respectively the contractual mechanisms that exist therein. And finally, few words about data. Now, data regulation is not new as such. You have a data regulation in force that existed for a long time when you use any payment instrument, when you use any credit card, any debit card, right? Nowadays, we discuss about personal data. Now, personal data, Law 45 that entered into effect in January 2022, is modeled in close details with the GDPR, in the sense that the subjects, the data subjects or data owners need to provide their consent in order to have their data processed. Things are very simple, however. How do we transport this into the business community? It is very important to analyze on a case-to-case basis, company to company, what kind of data we process, if such data is being transferred in international markets, if it is transferred from jurisdiction to jurisdiction, to which extent, and finally issue a set of performance norms applicable group-wide, organization-wide. We have a couple of banks as clients, for instance, and they are the first one that came with this requirement, do for us a group-wide procedure for the transfer of data and obviously for the consent and our liabilities as data controllers or processors. I think this is a new compliance overhead, and this is going to be translated in costs for any corporate setup, provided that at the federal level, there is a new governmental body which is formed. It's a federal authority on data, and the body is deemed to have an enforcement mechanism and obviously to apply the necessary sanctions in case of non-compliance. For a small limited liability company, obviously it might not be necessary to appoint a data protection officer. However, it is advisable that any company looks into what kind of hedge they have from a data perspective, how much they process. If they qualify as controller, processor of data, and do as needed. For markets that are more regulated, for example, the financial markets, you have a lot of other regulation of data that is not coming necessarily from the data protection law, but from the financial regulators. For example, if you look into a payment services provider, you probably have, let's say, a lot of data that comes from the central banks. For example, no data to be kept in cloud, the cloud to be accessible only from a certain jurisdiction, a certain cybersecurity check for any vendor. So from a technical perspective, the era when any third-party supplier was giving us data online, was sent to jurisdiction in UK, is probably over. I find these developments in the region as beneficial. The UAE is not the only one who has a data in place, data policy, data procedure in place. KSA, the Kingdom of Saudi Arabia, has done so a couple of months in advance. Egypt is new. So I think that we are in the wheel of a great development that is deemed to actually have a generational or intra-generational impact, and finally to create a legal hedge that was much needed in the region. Thank you very much. This would be discussion on commercial companies law. Now, of course, if you have any questions that you would like to ask, we'll be more than happy to respond.
I think it's working. Thanks so much, Laura. Can I ask, in the data protection law, companies that do not process large volumes of personal data, and before you said smaller company, what kind of size are we talking about? When do I know that I process a large volume of data?
For instance, a limited liability company that has 5 employees is probably not a processor of data, but or not even a controller of data. Like how we understand this difference between controller and processor is very easy. For instance, I access a website in order to look for something. The owner of the website is a data controller. Now, if the owner of the website uses the data that is collected by my web trace via cookies, beacons, associated technology, and this data is processed in view of, let's say, marketing services by a third party, that third party becomes a data processor. So there are many instances where the controller and the processor are one and the same person, but it's not always the case. So as a commercial entity, I'll need to understand how many employees I have, for instance, what kind of data I have from these employees, how do I process this data and act accordingly. Issue an organization-wide policy regulating how this data is processed, obtain the necessary consent from the employees while, let's say, entering into employment contracts with me as an employee. Further, obviously, we all have a huge online trace. So we all have a website that we allow users to access in order to look for information. Now, imagine that you are a business entity, Fichte Co, and you receive an inquiry online from a client. The same thing applies to, let's say, a ship broker or a ship manager that receives online a requirement from a client. At that point, the client is providing data, name, email address, phone number, location, address, at a minimal requirement, right? Now, for me as a website owner, I need to understand how do I control this data. For this reason, I need to have a privacy policy in place, a data policy in place to inform, let's say, the users of my website how do their data is being, how does their data infer with my activity as a company. Further, if I transfer data to a processor, for example, to create marketing advertisements, to do cold calls, yeah, I need to make sure that the consent of my data subject is being obtained in writing in order to avoid, let's say, any claims of breach of data, which are not new, by the way. Probably 1 month ago, there was a huge data-related case in the US for a web app doing transfers. Yeah? We all use them, online transfers of data. There was a data breach that affected a number of subjects. There was a class action in the US, which ended up with the settlement of $8 million payable by the data controller to the subjects. So when these things are going to be in full force and effect, their, I'd say, effects and implications on the business community are not going to be small. Further, if we look into the shipping community, for example, where we see a lot of software processed data, when we discuss about new and very flamboyant, fashionable concepts of artificial intelligence and autonomy, there is going to be a huge debate related to data. Because from a legal perspective, in data matters, we have a couple of kinds of liabilities. You may have a product liability, you may have a liability of negligence, you may have a contractual liability, etc. So overall, data is an overhead that needs to be tackled properly in any business community, otherwise it is cost, which is not.
Thank you so much. Excuse me. It is very interesting now that Dubai allows the SPV companies, right? My question was, are allowed also bearer shares, or so
Bearer shares, no.
All right, and is it DAD regulated?
Whatever comes under the realm of the Securities and Commodities Authority is an onshore company. This is the deregulated or in free zones, except the financial free zones, the IFC, ADGM, and the free zones that have their own regulation and opt out from the federal framework.
Thank you.
You are welcome.
Once again, Dr. Laura, I have to admit, your knowledge is phenomenal, and the way you're able to articulate it, it's spin of your hat is amazing. So congratulations on that. Begin with. Now, I have a question with regards to the 100% ownership. There seems to be some ambiguity in terms of the process and sector, which kind of fall within the realms of 100% ownership, and some of them don't. Also, we are not very clear in our mind whether is this applicable across the spectrum throughout the UAE, or is it only these laws are kind of more applicable from a Dubai perspective? To give you an example, we are an LLC company based out of Fujairah, that's where our headquarters is, and we've been kind of going around with the idea of understanding if we can have 100% ownership, and we were told that because we are into the ship owning and ship agency segment of the business, this would sort of, we would not fall into the right category. And apart from that, even if we have to move forward with it, because we already have, let's say, local sponsors, partner who's in the mix of things. We've been operating there for the last many number of years. How would that relationship be managed? Clearly, that would create some kind of friction, for want of a better word, which we clearly would not tolerate, of course. So, what is your proposition? First and foremost, whether this is actually even possible to begin with, and thereafter, if it is possible, then how will the transition happen?
Right, thank you very much. It's a great question. I think all the market is hesitating this kind of questions. The idea behind the 100% foreign ownership is very simple. If we look into the law is not saying from today onwards the foreign investor is allowed to own 100% of the business. It doesn't say that. It says that the regulators will determine a list of activities of strategic impact for the overall economy where they allow or they do not allow foreign ownership. That is the legal principle. How is this applied? The corporate regulators in various Emirates, Abu Dhabi, Sharjah, Dubai, have issued lists of activities that are open for 100% foreign ownership. For instance, I'm a shipping line agent. Yeah? Shipping line agents are now open for 100% foreign ownership. Things are clear. What do I do in order to reach that stage? Normally, I have a 49% share capital in my company, and the UAE national has 51%. Simply put, the UAE national sells the 51% to me. Therefore, once I notarize the deed of transfer, I would register a fresh memorandum of association with the corporate regulator, finally issue a commercial license, which would show me as 5% foreign owner. Now, things in practice can be slightly different because we have seen many situations where a UAE partner obviously cannot be forced as such to exit a company because in the end, it is a matter of losing income. So in this situation, what we usually do, we discuss with the clients whether they have a shareholders agreement in place aside of this MOA, whether, let's say, there is any way to avoid a shareholders dispute. There are ways to do that by simply negotiating, simply offering something counterparty, simply offering to the UAE national something in exchange of relinquishing his shares. For example, we've had a case where the UAE partner has reduced his contribution to the capital, a legit contribution actually, to 10%. By this, the foreign investor had the full rights to decide over the company, had the right to appoint the manager. However, the UAE national retained this 10% share equity, 10% on dividends, or otherwise as they have agreed. So from a corporate structure perspective, the possibilities exist. However, it is very important that your MOA is strong, your shareholders agreement is strong. If you have, let's say, the necessary contractual framework in place, so there is a cumulus of factors that need to be tackled in order to reach that result. As an overall recommendation, and this is something that we've been recommending from before, even before the Foreign Direct Investments Law in 2018, that the UAE shareholder would need to be preferably a corporate entity and not an individual. We've seen cases where, for instance, we needed to deal with inheritance. Inheritance for individuals took time, 1 year plus, situation in which, for instance, the company was quasi-blocked. If you discuss about the corporate shareholder, which is a company, now the company has perpetual succession, the decisions are made by the directors, so not linked to a single individual, but with a corporate that can function even in the absence of a certain individual. So more or less, in this framework, we discuss about foreign ownership fully. The bottom line is that the activity that the company is doing needs to be in the list of approved activities for 100% foreign ownership. It's not there. Obviously, it needs to remain on the 5149 rule as it was, until, of course, further developments. So I think I hope I responded to your question, Mr. Sati. Thank you very much.
All right. Good morning. Welcome back, everyone. Thank you very much for joining us. It's a pleasure to welcome our panelists. So I'm delighted to welcome back Dr. Laura Voda, Shehab, and of course, our newest member of the panel, Moaz. It's a particular pleasure for me as head of publishing Lexis Nexis to welcome this panel. This is some of our best and most widely read authors. So Shehab is the author of the UAE Legal Guide, and we were just talking this morning, in light of all the changes that keep happening, we probably need to discuss a new edition of that. And Dr. Laura is also a recipient of the Lexis Nexis Author Award last year, so it's a particular pleasure for me to have them here to answer all your questions. So I think to get started, obviously we are all in the transition phase. We have less than a year to be ready and to incorporate all the changes to UAE labor law. So with that, I'm sure you have many questions. Please do put those through, and we'll hopefully have time to get through everything. But to get these started, my first question is, we all know that we're moving from unlimited to fixed contracts. However, do we have to issue a new employment contract, or is a variation letter enough to implement the changes?
Hello again, and I just with the subject, I would like to apologize to my audience if my voice was not clear earlier. However, if you have any question regarding this topic, please feel free to contact me directly. You have my mobile number or my email, so I will make sure to attend any inquiry related to the previous subject. For Hussein's question, yes, it is mandatory for all the companies to adjust the status of their employment contracts within a year, starting from the enforcement of the new law. So they have 1 year to change all the contracts and to match all the requirements required by the new law. Otherwise, the fine is pretty heavy, which is up to 200,000.
Okay, and can you talk a little bit, I'll go to Dr. Laura here. If we're talking about notice periods, what has been the key changes there? What is the minimum maximum when it comes to notice periods?
That's a very good question. Thank you, Hussain. Thank you again, everybody, for being here. As you know, the most prominent change comes in the notice periods because, for instance, in the previous law, if an employee was to be terminated or resign, he could have done so without a notice period. Now, according to the new law, the notice periods are mandatory, even in the notice period, in the probationary period. The probationary period would not exceed 6 months, and the notice period is set at minimum 14 days. Now, if we discuss about the remaining of the contract, after the employee has been confirmed, there is a new provision that implies that notice periods for termination or resigning are set at 3 months. Actually, in the law, it's 90 days. So these would be, let's say, the maximum brackets applicable for notice periods. Overall termination with notice is the rule, and this is not new. This existed in the old law, and the same principle is present in the new law as well.
Thank you very much for that.
Thank you.
The next question I would like to ask, is there a minimum wage? And if not, what benefits in kind form part of the basic wage for the purpose of calculating employee benefits? As if I can ask the question.
I don't think that, can you hear me now?
I don't think that the minimum wage is decided yet. It will be decided by the Ministry of this year, which will be issued, I think, in about 3 months, right? What was the second question? If you're trying to calculate what constitutes basic versus additional, the calculation of head of service, it will be always based on basic salary, not the bottom salary. So there has been no changes in the calculation. It will be calculated as did the old law. Now, obviously, this is very different than the LSC in terms of this. It's not a mandatory minimum requirement there, but what is your advice for employers in terms of getting that balance between what is considered basic for the purposes of the service and additional benefits, whether it's accommodation or transport allowance? What's your advice in terms of achieving that balance?
In the law, you don't have a statutory standard for this distribution. The market onshore tends to be pretty heterogeneous when it comes to calculating employment benefits. However, we've seen from practice, for instance, that a lot of employers tend to offer to the employees a very low basic salary, which would reflect in their payment of gratuity at the end of employment. This is not always the case. Normally, in, let's say, most of the SMEs, we've seen a distribution half basic, half allowances, such as transportation or housing allowance. In mainland, onshore UAE, you do not have a mandatory contribution that is payable by the employer as it is, for instance, under the dues in the DIFC. However, nothing stops a mainland company from contracting privately funds, pensions, in order to provide additional benefits to the employees, and we've seen that in a number of cases. The law is only providing the minimum standard of end of service payable. However, if the employer wishes to grant additional benefits at a higher scale to their employees, the process is perfectly legal and approachable from business, legal, financial perspectives as well, by demand as well.
Thank you very much. A key point that came out in earlier discussions, people asking, is the changes to end of service gratuity. As far as how the employer should go about preparing for that, whether it's making allowances with the finance team or informing the employee if they need to. What would your recommendation be there for the parent?
It's at the end of the day, it's still under the management agreement between the employer and the employee, how things should be tackled. And as per the new law, it's which brought a lot of questions as well to us. Is like, what if I have been someone with the company being with it for 7 years, an unlimited contract, and then as per the new law, this unlimited has to change to a limited contract, which will impact the calculation of end of service. Should the end of service be continuously calculated all the employment life period, or it will be divided, and whether it has to be advised to the employee by the employer or not? As per the new law, the previous calculation should be according to the old law for the unlimited contracts, and starting from that implementation of the new law, the end of service should be recalculated from the beginning. However, one good thing in the employment law in the UAE, anything in adding more benefits or value to the employees' rights, the law will never, or the judges or the court will never oppose it. So if it's been agreed that the end of service will be continued as it was previously, then there is nothing wrong or nothing to be against the law. So this is, as I said, it has to be a mutual agreement between both employer and employee. There is no obligation on the employer to provide such information at this stage, and that's how it is.
Okay, from a personal perspective, I'm also a general manager of Middle East. We're in the process of updating our contracts and everything else. Where do you guys stand on end of service gratuity calculators? I'm just saying, you can actually find some on the Dubai Development Authority. Others, are those up to date? Are they reliable? What's your thoughts on using those calculators?
It is efficient at a certain point, and however, it is advisable that always the finance department in each company has records for that in a year, if not month-by-month basis, a yearly basis. So the calculation at the end of the day will not be a big hassle, and it's already in that record, and it's always to be double checked internally and not depend just on the calculation, because you never know whether the information will be added is accurate or not. The last basic salary, all this kind of information need to be correctly done, and the record for that is kept internally in the company.
Right, thank you, Shehab.
But then, if I may please add something to that. You see that most of the commercial regulators have their own calculators. For example, if you look into companies in the MCC, they have their own calculators and a procedure for explaining the finance departments, etc., how to calculate an end of service gratuity, etc. We've seen cases where, for example, different methods of calculation provided different results. And therefore, we do advise the employers or the clients, as the case may be, to give the most favorable thing to the employee, because this is in the end an ethical thing. However, the problem that I think that we wanted to touch is what is happening with the gratuity accumulated prior to this entry into force, which now needs to be somehow reset, right? Post entry into force of the new law. For instance, you have an employee that has worked for 5 years. As per the old law, at the 5 years bracket, the employee becomes entitled to 30 days gratuity at the end of employment, whereas the new law is making the reset that to 21 days. So basically it comes from zero again. That's a quite complicated situation, and we have received a number of questions from our clients on that. We have seen colleagues asking about that because they feel that they have been deprived by certain rights. Now, from our point of view, as lawyers, but then again, this is our point of view, the gratuity that has been accumulated prior to the entry into force as a quantum needs to still exist and be payable to the employee. Now, the problem appears, how do you transfer this gratuity as to the new law? Because, for instance, if I start my gratuity from zero, I'll start at day 1. If my contract of employment is continuing, I'll start from year 6. So, from our point of view as lawyers, yeah, this continuity needs to be granted to the employees. However, we are still expecting for the Ministry of Labor to come up with clarifications, because in the end, it would be difficult to deprive an employee from a statutory benefit accumulated prior to the entry into force of the new law. So this area still would probably need to be clarified by the regulatory authority.
Might be pushing my luck here, but on that particular point, in the new contract, could you give advice on drafting reference to the service gratuity from previous accumulation?
Yeah, that's possible. What is happening in the onshore employment contracts, as you probably know, the Ministry of Labor is issuing templates of contracts, templates of offer letters. These are basic and are largely uniform, applicable everywhere in the market. Aside of that, there is nothing stopping a company, an employer, to write additional contractual provisions, additional variations, subject to complying to the standards that are imposed by the Ministry of Labor. So, although many people say that, you know, we don't have much contractual freedom because the contracts are being standard issued by the Ministry of Labor, no, this contractual freedom exists. There's nothing stopping an employer to provide more rights to the employee, subject to contract, and subject to a contract which is properly made. So there's a possibility to respond to Hussein's question there.
Thank you very much. think I'll open it to the floor. Are there any questions you would like us to delve?
I'm sure there's a lot of questions. Can I just ask, before I give it up, I'm like you, Hussain, I'm not here as a lawyer, but as an employer. The first point on a new law, I try to understand is which direction is this going. And the first thing we heard on the announcement was equal pay, yay. We heard no bullying. Okay, now everybody can sue me if I say mean things, and I say a lot of mean things all day long. That's maybe not so good for me. But then what is really good is all the different new visas. Because before we had problems, I like offering jobs to working mothers who can only work part-time. We couldn't work it out. Positive. Now the limited contract is really confusing me. Limited was for me always for blue workers. Unlimited is what all of us have. I don't understand why we need to change. And now obviously the discussion comes, gratuity has been decreased because normally after 6 or 7 years, your gratuity goes to 30 days per year.
After 5 years.
After 5 years. So now it's only, I don't know why that was decreased. I don't understand it.
It's not really decreased. It's the law, which is article, I believe, if I'm not mistaken, 68.3 gave the right to the employer to calculate the end of service as per the unlimited contract. So it's still, as Laura said, still unclear. But how the employer and the employee will agree on the recalculation after registering the new contract according to the new law, making it limited from unlimited, it's still the right to make it, reset it and make it 21 days exists, and the right to make it 30 days still exists, putting in consideration the number of years that the employee has been working in the company and the relationship that they have. And as you said, it is a bit confusing. Why to change? Why to reset it? If I am in the company for that long, why do I need to start from the beginning? Go back to 21 days. But the difference here is, previously in the old law, if I resigned before 3 years under, and I'm working under a limited contract, my gratuities is not 21 days. My gratuities is actually 7 days per year. If I resign, it's only 21 days if I have been terminated before completing the 5 years or during the first 3 years for me in the company. So the new law has removed that. The new law has unified it, which is 21 days, despite whether I resigned or the company has terminated my employment agreement. And as Jasmin said, with the benefit of that is having a lot of different visas happening here, which is attracting a lot of talents, a lot of new ideas, a lot of startups, a lot of people who need to be here just and be legally working and have the license to work without joining an organization or without. So we bring more refreshing to the industry. We market more the country. We've seen a lot lately, a lot of influencers from all over the world. They are here, which is a trend now. YouTube, Instagram, Facebook, TikTok. These people now, they have to be licensed to do that, which bring business to the UAE, put more eyes on the UAE market, which is a very important thing. I believe so.
I think it would be nice to expand on that point about flexibility, the easing of restrictions in terms of moving between employers and flexibility to have different periods with contracts. Laura, if you could touch on that issue.
Sure. This flexibility did not exist prior to the entry into force of the new law, provided that at the time we're having only limited, unlimited contracts and a very limited portion of part-time or work per day or per piece. Nowadays, things have changed, and provided that the market trends are different, obviously this needs to reflect in the type and quality of employment that we hire. I was reading the other day in the executive regulations, the rules of issuing part-time contracts and co-shared job contracts. It's very possible that, for instance, for an 8-hour job, for instance, sales, You have this job to be split in between two employees working in shifts. This is very usable for certain industrial sectors, for instance, transportation, taxes, to name just a few. In terms of legalities, the contract will need to be issued as such, and the calculation of gratuity at the end of the employment is to be done pro rata, and the executive regulations actually provide the exact mathematical formula for that calculation. So I don't think that that's going to pose issues in the market. There are going to be special categories of visas issued for such employees. And in the end, it's a matter of employment structuring and how the respective companies will to contract their respective workforce. From a contractual perspective, I said the workload is divided pro rata, and more or less it's the same principle that applies in various other legislations around the world, including the DIC.
Thank you very much.
And let's quickly wrap this up. There were a number of questions. I know you're shaking as well, I can see it. I know Hussain would be, he will be upset that I make such a fuss about it, but it's just scared me. But Ivy, you want to ask a question?
Yes, please. I hope you cover so these things happen. The question is, maybe you replied earlier, I'm not 100% sure, but once the companies have to change these unlimited contracts to limited, what happens with the end of service benefits of the employees? Do they have to be settled, terminating the unlimited contracts, starting new ones, or can they be transferred, or what is in practice? What is required to be done?
In practice, it has to be done as per the old law. So if the employment contract, previous employment contract exceeded 7 years, so you have the first 5 years, it's been calculated 21 days per year, and the other 2 years above the 5 years will be calculated at 30 days per year. So this has to be calculated before the enforcement of the new law, not from the start of issuing the new contract. So it is, if I've been with the company for 7 years, so my end of service will be 7 years calculated as per the old law, if my contract was unlimited, and will stop the calculation there starting from the 2nd of February 2022. And as we said, depends on the discretion and the agreement between the employer and the employee, whether the same calculation will continue or it will be reset according to the new law. And you are not obliged as an employer to pay it now, but you are obliged to calculate it at the end of the employment agreement as per the old law. So we advise that once most of all the companies to calculate the end of service for their employees who has exceeded 5 years, and just to keep it on the record that, okay, this is the end of service for such and such employee until that date, and then either we continue with the same calculation or restart it as a 21 days as per the new law.
So if the employee is saying, but I don't accept it, that you reduce it now to 21 days. Is that the reason to say from my side as an employee, if you don't keep me on 30 days, that's the reason to resign?
Not a reason to resign, and because that's the law. You are not doing anything against law. You are not forcing your employee to take something which is not being agreed. It's what does the law say, so it is the employer's discretion whether to continue with the previous calculation or to restart.
Does this not give unscrupulous employers the ability to continually pay 21 days? You issue a 3-year contract, and then at the end of the 3-year contract, you don't pay it out, and then you start a new 3-year.
I understand your point of view, but the law does say otherwise, because the law says if like the calculation for the first 5 years is 21 days. Any year additional to this 5 years will be 30 days. So the terms of the calculation is remaining almost the same. The only difference is the reset and the making the contract limited and not unlimited. So according to the new law, if I stay with the firm for 7 years, so the first 5 years I'm getting 21 days, the other 2 years, additional to the 5 years, I'm getting 30 days per year. So it's almost the same.
So if it's reset, should the employer not have to pay out the original 7 years?
That's a good question. We got a lot of queries from our clients saying, can I now, I understand it. Currently there is a version, English version around, what says you can now ask your food gratuity to be paid out. I asked you and you said no, the Arabic law clearly says you cannot. But there is a question. Obviously, I would be a bit worried on our cash flow. We have a lot of stuff being with us for 40, 50 years. Yeah, that would be, so don't put anything in anybody's head. But we have exactly the same question to say, is that, can they ask us now to be paid out? Or can we make, but we have to make it very clear in the new contract to say, obviously, it will be taken over. It has accrued and it's there, but it has to be very clear in the contract for the staff.
In general, as long as the employment relationship exists and is not terminated, so it is a clear indication that the end of service is not being paid. That's why it's called end of service. That's why it's called gratuity. It's only paid upon the end of the employment agreement and the employment relationship. That is what one thing we don't.
So why a fixed contract?
The only thing that changed is, as we said.
Why limited? Because limited at 3 years limited. So if 3 years is gone, the contract is finished. That's a difference.
Unless renewed.
But it would be end of service. That is, or you say, okay,
Not
this is renewed. That is not.
Yes.
So it's an unlimited, limited contract.
Yeah. I'm confused.
It's renewable energy, we would say that. So it's.
Yeah, but you just say that on the 2nd of February, you reset your contract. The old employer has the right to reset your contract. So the first 7 years that you worked, back to zero. Should we not pay at that time? Or we can wait? Why should we wait to be paid later if you want?
It is
If you reset. If you reset.
It is up to the employer whether the employer wants to pay or not, but there is no obligation. We don't see a reason for paying it as long as the employment relationship still exists. Because it's still existing, there is still, it will be accumulated until the end as a full end of service.
Yeah, it will be accumulated, yes, but it will go back to 21 days.
Starting, yeah, the calculation will start from the beginning, yes.
What is the obligation of an employer to go back to these 21 days? Is it mandatory or is it
not mandatory?
Negotiation.
Not mandatory. The law says the employer has the right. Didn't say the employee have to.
Could I ask, yeah,
Good afternoon. I'm not a lawyer. However, what I understand is that there are two principles, and I think in Europe that would be contested. It's either the duration of the employment which matters, or the duration of the contract. If, as an employee, you can prove that you have been employed with a company, irrespective of the kind of contract, for more than 7 years, then this should be applicable even if the duration of the new contract will only be 3 years, right? So that's the duration of the employment. Otherwise, it's the duration of the contract. And then, if that is the case, then when you end the contract and you start a new one, you are entitled to get your end of service gratuity. And that should also be respected. So I think that is not clearly stated from the authorities, and that in a German court that would be contested. And it would have to be defined one way or the other, and perhaps you should also play that back to the Ministry of Labor, that has to be more clearly defined. My guess, why limited contracts? Because I guess you will have to register them with the Ministry of Labor every 3 years, and you will have to pay a fee, the registration fee. Yeah.
Business oriented.
Yes, there was one more question, because I still want to come to one point on the non-compete, what I find really important, and where I have my own question. Question? No? Yeah.
So for the fixed term contracts, the 3 years, after 3 years, do you make an addendum to just renew, or it just goes by?
The contracts, the employment contracts are registered, all of them here, right?
Yes.
With the Ministry of Labor or with the respective corporate regulator for certain free zones. So at the end of the contract, unless the contract is terminated, yeah, the parties, respectively the employer, will apply for the renewal. So more or less this is an administrative procedure and is in place even now, because till date we do have limited term employment contracts that are subject to renewal in a specific time frame. If they are not renewed as per the old law, they are deemed to be continued. However, this administrative procedure would still need to be put in place for visa purposes, for residents, for employment cards. Yeah. So this particular procedure is maintained and will be applicable even from now on. So we may not presume that if a contract is terminated at, let's say, at the end of the 3 years period, the visa is cancelled and the full employment relationship is finalized. One may not presume that, because the employment contracts here have this, statutory mechanism of renewal and of registration, which needs to be done anyway. For instance, even if at the end of the 3 years period the contract is terminated, the employer needs to operate in the Ministry of Labor system certain changes proving that employment law, employment contract, is indeed terminated, and that employee is not under employment visa with the respective employer. Otherwise, there are penalties payable, and these apply even now. But according to the new law, when you have a 3 years contract that comes to its renewal term, yeah, at that point, these administrative changes need to be operated in the sense that either the contract is terminated and the parties are free one from the other, either it's being renewed for a similar period of time. So from our point of view, indeed, many people are looking at these legalities from the point of view of other legal systems. I completely understand. The UAE legal system has certain particularities because it's one of the few jurisdictions in the world where the residence visa of the employee is linked to his employment status. In Germany, for instance, or in Europe, if you want to become resident of the state, this is not mandated by your employment relationship. In here it is. So this limitation of 3 years is not to be deemed as a limited contract per se, but an administrative limitation to the period of contract, yeah, and to the period of business and to the period of visa, right? So there's a linkage in between them. So this limitation appears from our point of view more or less as an administrative thing, and in order to ease the burden that exists on the companies in the market. You have single type of contract, this is what you have to do, is clear cut. That's how the regulators see it, actually.
And as well as, sorry, it's just to add on Laura's here, the visas in general, even for limited or unlimited contract, they were either 3 years or 2 years. So they used to, it's a must to be renewed at the end of that, whether the contract still was valid or ended. So now what will happen is the visas will be issued as per the contract duration. If the contract is for 1 year, so the visa will be for 1 year. If the contract for 3 years, then the visa will be for 3 years. So the duration of the employment contract is the same duration of the visa, which was not applicable before.
Thank you. I also have a second question. For the current contract, was actually mentioned this question before, but I did not quite get the answer.
is it fine if we just make an addendum where we modify, instead of unlimited, here's a contract limited for 3 years? Is this correct? Instead of just making a new contract, just an addendum will do according to the new law?
No, it has to be a new contract registered in the Ministry of Labour under the new form provided by the Ministry of Labour, as well as it has to be matching with whatever additional provisions they agreed between the parties in the internal contract between the employer and the employee. So just that amendment will not be sufficient for this year. However, it will be sufficient for next year's, all the coming renewals. Yes, an addendum or even not an addendum, an email, or just continue the working relationship and renewing the visa, this should be sufficient enough to renew the contract according to the same terms and conditions and provisions of the previous
One question here. So but I would like to bring it to one more point. We have Murphy's Law, we have the renewal. Oh, excellent. I just got the message that Hussain is feeling better. Sorry. We had 2 new onboarders on the 2nd of February. So our HR manager comes running to me and says, I don't understand it. There is, apparently you need to put the non-compete clause in the contract now, or you're facing a fine. So the non-compete clause, that is something what I do not understand, because it's literally saying, you, Chris, if you leave in your company, you cannot work with any competitor for the next 2 years. So from what way you live? So not only direct competitors, we are in shipping, we are in a very close community. Does it mean one of us is leaving? We cannot work somewhere else. You are leaving, you cannot work for any other law firm in the UAE for the next 2 years?
I bet you would allow me to.
No, but that's, and we needed to put, so she was saying, we are facing a fine if we don't put these clauses in the employment contract, but I don't understand it. I looked at the law, I didn't understand it, because I want, of course I want to protect my company, but a lawyer, if somebody is leaving, they need to make a living. I cannot bar them from working for a competitor. That I did not understand.
We have here one dear client for us suffered from the same thing, the non-competition clause, which was completely an act committed by previous employees, and even taking the data, the same website, same design, everything is clear to the court according to the previous law that they have breached the non-competition clause in their contract, and the court has rejected the claim. And they are not doing any profession like doctors or engineer or lawyers or something that they cannot do otherwise. They were doing sales, property sales. So I still think, yes, it has to be there according to the law. However, how it will be applied, it will be under the discretion of the court. There will be no changes in that. You can still complain if someone leaves your firm going to a competitor, direct competitor. You can complain to the Ministry of Labour that do not allow this person to work because they have all the data, they know all the information, the contact details of the clients, and they have very important information which they cannot take with and use it in their new job. However, this will not be closed before the Ministry of Labour. It will be turned to dispute, and then the court will have to decide on that. How it will be applied? God knows.
So do we need to change our non-compete clauses
The way
now?
I read the law is that this non-competition clause will not be applicable to all professions. There is exceptions. I don't think the lawyer will be.
And shipping, maritime industry?
There is the exception. The Minister of Labour will issue a list for exceptions.
Minister.
2 years paid leave.
We are saying.
We asked him as well.
If it's 2 years garden leave, it's okay. Like you cannot work 2 years for anywhere in your industry. How is that supposed to work?
The law itself says that it will not be applicable to all professions.
That is true.
So when is the update? When is that expected?
No, but there's a lot of discussion to be made in this respect, because there's one thing to put a non-competition clause in the contract and a different thing to have other types of restrictive covenants. For example, if your employee is running away with your database of clients, this has nothing to do with a non-competition clause. This is has a lot to do with what kind of restrictive covenants you put in the employment contract, because yourself as a company would need to protect the assets that you have, whether these are tangible or intangible. Your database of clients is subject to proper non-disclosure agreements that need to be entered into with that particular employee. Let's remember that in any restrictive covenant, the burden of proof lays on the claimant. In most of the cases, this claimant is going to be the employer, not the employee. So in the end, it is a matter of structuring and how well, as a company, you manage to produce documents showing that supposedly a database of clients is yours, that it has existed on your servers or in your internal, let's say, documentary files, and it has been subtracted by that employee. And if this is the case, then you have a lot of sectorial legislation that would come to support. Because if, let's say, an employee is running away with the database, there's not only an infringement of your non-competition clause or a restrictive covenant, whatever is in the contract. This is an infringement of a cyber protection law, and there's a lot of other heads or other counts that would help an employer to actually build a solid case. Because so far, until date, what we've seen in employment contracts as restrictive covenants was the extremely general clause that an employee that serviced an employer for a number of years is not allowed to work anywhere in the UAE under the same position. Now, why the law is putting certain brackets into its provisions is for the following thing. A restrictive covenant of any type, non-competition, non-solicitation, non-disclosure, whatever applies post-termination of the employment contract as a restriction to the employee, needs to be, number one, properly built from a contractual perspective, number two, needs to be exact, and number three, needs to have a very strict territorial limitation. For example, if you are a company in DIFC, yeah, a valid contractual limitation would be the territory of the IFC or this non-competition clause. If you discuss about data and non-disclosure of data, for example, as a restrictive covenant, that can have a wider reach because, for instance, nowadays you have the modern technology by which you can communicate anywhere, anytime. So, all in all, a proper non-competition clause needs to be built accordingly and to have certain limitations. And I have to agree with Moaz. The law is specifically taken out of this realm certain categories of professionals, right? For instance, if you are a doctor, right, you cannot go and work as an accountant. You're not qualified for that. The same thing would apply for a lawyer. So professional services in general would probably not fall under the same realm. However, if we discuss about the person doing sales, right, or a person doing, for example, let's say other types of jobs such as business development, commissioning jobs, yeah, that may be subject to certain restrictive covenants. However, we draw attention over the fact that the mainland courts do not have uniform jurisprudence in this respect, and in most of the cases, the restrictive covenants have been deemed unenforceable. And not because the law is very wide, just because the contracts at issue are improperly drafted, and the companies at issue did not safeguard their interest to all their assets, tangible and intangible. As said, most of the companies that exist in the market limit themselves to enter employment contracts as per the standards issued by the Ministry of Labor. These standards are very good, but they are minimum. There's nothing stopping you in structuring your employment relationship properly with a lot of performance forms via policies, addendums to contracts, etc. So this is a job by itself. But in the end, there is a way to, let's say, to protect yourself as an employer against this kind of infringements, and in the end, it is a matter of contractual structuring, nothing more.
Thank you very much for your last question.
Sorry, just getting back to you, because as we know, we operate some coastal vessels in the UAE, and all the seafarers are connected with a visa operating. If most of them leave after 1 or 2 contracts, and then if anybody leaves within the 2nd of February, end of the year before we issue a new contract, what will apply? Is it the previous one, or is it the new law that will apply automatically from 2nd of February?
But it depends on the period that they actually left from your service.
Yeah.
So if they left, obviously you don't apply any contract because they left.
Yeah.
Right? In case of renewals, right? The renewals would run by the new law from the time of entering force of the new law.
Okay, so let's say for example,
Right.
he leaves tomorrow. The end of service will be his previous contract conditions.
Correct.
And at the end of the day, it will not be much difference because they will not be on board of the company for more than 3 years.
Sometimes, yes.
Very minimal, or not more than 5 years, I would say. So the calculation will be ended up in 1 day. If you are talking about relativity. So and just to tackle one point in regards to the non-compete clause, yes, there are some professions will be excluded. However, it's not out yet, and it will be decided by the Minister of Labour, and according to the executive decision which came out. And to be more clear on that, where it does apply, because the same terms and conditions almost the same to all all terms and conditions for the non-compete clause, which has to be determined by area, by time, by type of work. It does apply before, and I've seen it in a general manager for one networking company has moved to a direct competitor with the same position. Here, the non-compete clause did apply because it did apply in the same area of Dubai, in the same area of work, and the same clients as well. So their clients is you can count them on hand because they are a whole provider. So that's where it applies. And at the end of the day, as I was saying, it will be at the end of up to the discretion of the judge to see whether this employee should not join this next employer.
I think your question is very important because my initial was as well, oh my God, on the second, we have to change each and every employment contract. So 15 million employment contracts have to be changed. Then we said no, it's over the year. Any contract that comes up for renewal, the new law will apply. At the moment, old contract is still under the clauses of the old law. But as I said, we were unlucky because we had on board us on the 2nd of February, where we hadn't changed our employment contracts. So it wasn't clear because still a number of things are not really clear how we drafted, where we followed or where we not followed. We cannot decide, do we follow the new maturity law? We need to have a partner meeting. I would like to stick to the old one because this is budgeted with us to say, you have been 5 years with us. It's a loyalty question for me. You should get 30 days. I don't want to set it back to 21 days, but I need to wait for the next partner meeting. That it will take time in every company to actually get the new systems in place.
And just for not making people panicking regarding the time frame where you need to be adjusted, this time frame has been set 1 year. So we have until 2nd or 1st of 2023. However, if the minister see or felt that this time frame is not sufficient enough, it will be extended. So there is a possibility that this year might be extended. However, it will not depend on that. You have 12 months to work on it. adjust your status according to the law to avoid any problem you may face next year.
Thank you so much. I think we have to stop it now. Any further question, you can still ask outside. The online audience, you know how to reach us. Hussain is better, so I hear if you are worried, don't contact him directly. Everybody today message us, we will keep you posted. I hope he is okay, but we will check on him right now. Thank you so much, online audience. As many feedbacks as possible, please. This was our first hybrid event. You couldn't hear us, you could hear us too loud. We like to hear a bit more. You find it good to hear a question. Without seeing the person who asked the question, let us know so we know it better for the next event. Thank you so much for the speakers. Thank you for listening.